is Curtis versus Townhill Prime Insurance Company.
Good morning. May it please the Court, I'm Tom Elliott here on behalf of Robert and Darlene Curtis, who are here appealing a summary judgment that was entered against them. There's no dispute they have over $100,000 of damage to their home. The summary judgment was entered on two erroneous grounds that I will speak about in a moment. But before I reach that, even if they had breached some policy provision, which they didn't, as we'll discuss, the law is clear in this district under the Macrillos case, if I'm saying that correctly, authored by Judge Northcutt, and then the Jurovat case. I don't know how to pronounce it either. The Jurovat case that came right after that, that when the insured cooperates some, it presents a question of fact that precludes summary judgment. So on that basis alone, the summary judgment must be reversed because the insureds showed the property at least 5 times. That's at page 119 of the record. Unless there be any question about this, this was specifically brought to the trial court's attention. This law at page, volume 5, page 747 and 8 of the record, counsel argued if the insured cooperates to some degree, that presents a fact question. Despite that, summary judgment was entered. So on that basis alone, summary judgment needs to be reversed. But I would hope that the court, and if there are any questions on that, I'm happy to answer those, try to answer those before I go on to the substantive bases. Okay, the two grounds on which summary judgment entered were both wrong. The first one was based on the so-called loss payment provision, and that appears at page 27 of the record. The loss payment provision tells the insurance company when it has to pay after certain things occur. When there's been a judgment, when there's been an appraisal award, there's been a mediation, a certain number of days. It is a duty on the insurance company. It does not limit or tell when the insured files suit. And that's obvious from the wording of it. They want to make the argument, well, you can't file suit until you've complied with the loss payment provision. Well, one of the things is to get a judgment. That's one of the ways you trigger paying. How do you get a judgment if you don't file suit? That's just an absurd argument, with all due respect. The provision they would like to rely on is, appears on the page before that, is the suit against us provision. And that says no action can be brought unless the policy provisions have been complied with and the action started within 5 years. Okay. All the policy provisions were complied with here. The only two arguments they made a third one the trial court rejected, and I'm happy to talk about that, but the two arguments they made were you filed suit against us in violation of the loss payment provision, which doesn't apply to the insured anyway, and they also argued about the filing suit when neutral evaluation had been requested, and I'll speak to that. But in terms of the loss payment provision, Judge Kuzan, this may look very familiar to you, because this is the exact same argument that was made in the trial court below in Panjikaran that you wrote the reversal in. Now, by the time it got to appeal, they had a different appellate counsel, and they had abandoned that argument, and they made a different argument. But this is the same argument, different carrier, but same trial attorney made in the trial court below that was wrong and was reversed.
Well, let's set that aside.
Yes.
Let's
okay.
Focus. Let's talk about the neutral evaluation.
Okay. I'm happy to go there, but just quickly on the loss payment, the cases they cite don't stand for the proposition, even if they were right and that was some kind of limitation, you don't dismiss it with prejudice. The Shook case that they cite from this court, what they did there was they say you stay the case or you dismiss it without prejudice. So they don't get the relief that they suggest. Let's go to the neutral evaluation statute. The plain wording of the statute does not prevent filing suit. What it says is, this is subpart 11, 627-7074, subpart 11, 2010, and the 2010 version is the one that applies. 2011 is the same on this, so it doesn't really matter on this point. But the 2010 version says, any court proceeding related to the subject matter of neutral evaluation shall be stayed pending completion of neutral evaluation. It does not say you can't file suit. I mean, you can't stay something that hasn't been filed. Paragraph 13, subpart 13 says neutral evaluation recommendation is not binding and, quote, the parties retain access to the court. What they have done here is taken the statute and denied the Curtis's access to the court. Now, then they make the argument and say, well, our policy specifically incorporated the neutral evaluation stay provision and said, oh, you can't file suit. It does not say that. Their policy at page 43 has the sinkhole loss coverage endorsement, 43 of the record. Under neutral valuation, it says, following receipt of a sinkhole, blah, 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 loss claim, you, the insured, may participate in the alternative dispute resolution or neutral valuation. Then it goes on to say, for disputed claims, provided by section 627.7074. No subpart cited. No subpart mentioned. Now, they filed an affidavit from one of their people at Tower Hill that said that the subpart 11 was specifically incorporated in their policy. It's not. I don't know what Tower Hill calls that. I think you and I would call that a affidavit that's not true, but there's a name for that technically, but we don't need to go there. It's a false affidavit. It doesn't, the statute does, the policy does not specifically incorporate the statutory stay provision. Even if it did, a stay is a stay. It doesn't say you can't file suit. If you're going to put a limitation on filing suit, and there are some statutes that do that, as you all know, the med malpractice statute says you've got to do certain things before you can file suit. That is completely absent from the neutral evaluation statute. Does not exist, not there. The claim that it does is simply wrong as a matter of law. And so while this court, I would hope, would reverse on the grounds that there was some cooperation, clearly in the record, and that requires reversal, I would hope to go on and write and give the trial court some guidance on this, because this is not the first case that either one of these things has happened in. Okay, you see the argument. They've argued the lost payment thing from Miami to Pensacola, urging error across the state. As far as the neutral evaluation case goes, there's a notice of related case. You've got another one coming up, different panel, but it's coming up for oral argument within the next month or two. So guidance on this issue would be helpful to all the trial courts who are dealing with this issue. Okay, so neutral evaluation statute does not preclude filing suit. There is yet another reason why these rulings were wrong on the merits. Either one of these things. Let's assume that the statute did say, okay, you don't file suit, and it was incorporated, neither one of which is true. But let's assume for the purpose of argument that that had been the case, or that the lost payment provision somehow did apply. Where's their prejudice? To get out of honoring their policy obligations to these insurers who have $100,000 plus loss on their home, they need to have some prejudice. And it's clear if you look at the case law, prejudice doesn't mean coming in and having to have a suit. That's not prejudice. Prejudice means a lack of ability to investigate the claim.
Wasn't the neutral evaluation completed?
It was, yes, Your Honor, it was completed. What happened was the carrier demands neutral evaluation, invokes it. Well, actually, let me take a step back. What first happens is they send their report, the insureds, and they say, you got to fix the property according to our report. The insureds say, hey, we don't think that's right. We want to consult with you as the statute mandates. Statute in 2010 mandated consultation. That's why they don't want the 2010 version to apply, by the way. And does Tower Hill consult? No. It invokes neutral evaluation, so the insureds file suit. The case goes to neutral evaluation. The insureds don't do anything during the suit, during the neutral evaluation, except go to neutral evaluation. Now, Tower Hill files motions for summary judgment while there's a stay in place. Right. And they say, well, there's nothing wrong with us doing that. How you can not file suit when there's no prohibition, but you can file summary judgment motions when it's stayed, escapes me. But that's their position. So neutral evaluation is completed, and then the suit comes back out of the stay process. They have their motions for summary judgment heard, one of which is you shouldn't have filed suit.
Well, the point I'm trying to make is that, as I read the record, neutral evaluation was completed.
Yes.
If it's completed and the neutral evaluator renders a conclusion, how was Tower Hill prejudiced in the investigation?
They are not. They already had, for example, they are not. That's exactly right. And that's his point. There is no prejudice to Tower Hill. And this court's opinions make clear what prejudice means. You look at the Pena case, which was authored by Judge Casanova, who's not here today, but
he'll be here in a bit.
Okay. Well, happy to have Judge Slade here. But you look at that case. There's a case where the insureds filed a fraudulent contract. They made up a contract that they said they'd entered into, and they hadn't. That, as this court said, held in that case, that's not sufficient for the insurance company to avoid coverage on substantive coverage defense. And Judge Sleet's exactly right. There's no prejudice to carry here. It investigated. It was out of the property at least 5 times. sending its people out, its, the engineers and stuff. I mean, the engineers render a report that says there is a sinkhole here. You've got sinkhole damage. That's not the dispute. The dispute was what's the right fix.
You know what's interesting, Mr. Elliott, is that at the beginning, before all of this, Tower Hill actually, in a way, acknowledged that they owed a certain amount of monies for about repairs. And I guess what I'm having a trouble with, how did the court totally dismissed any claim whatsoever when there's an acknowledgement by the insurance company, at least they owed something before even you get to the neutral evaluation, before you get to these other matters. And perhaps that's an appropriate question for Mr. Russo, but that's what I'm concerned with.
And we're concerned with that too, Your Honor. And that's why I encourage the court to write, not only to say, look, they cooperated, so the summary judgment's got to be reversed, but to say, look, this lost payment provision is not a valid argument, and this filing suit before neutral evaluation is completed is not a valid argument. Those are just fallacious arguments that the trial court bought into here. They're just wrong. And I think a written opinion that goes beyond just they cooperated so we got to reverse and addresses those two things will provide guidance throughout the district so that this doesn't happen again. Because it's happened, the neutral evaluation thing's happened at least twice, and according to their own memos, this lost payment provision argument, works all over the state. Now, I know from experience it doesn't work with every judge. Some are astute enough not to buy into it, but it has worked. I accept their statement of that. And that was actually my next point, Judge Lee. No prejudice. They have suffered no prejudice here. Even if the insureds had done something wrong and put aside that they cooperated, so that wiped it out, there is no prejudice of the type that has to occur for them to be entitled to a forfeiture of coverage under the policy.
Is there a forfeiture provision in this policy?
No, thank you, Your Honor. There is not. There are policies that say if you do any little thing wrong, you forfeit coverage. Or there are some provisions that say, I'm not sure we have that kind of policy in Florida, because I'm not sure the Department of Insurance would approve that, but there are provisions that say, well, if you commit fraud, then you forfeit coverage. That doesn't appear. There's no forfeiture provision for violating the lost payment, which doesn't apply to the insureds anyway, or for filing neutral evaluation or filing suit with neutral evaluation. There's no lost payment, there's no forfeiture provision there. And and they acknowledge under the Indian River Supreme Court decision, if you don't have a forfeiture provision, you don't get a forfeiture. But then they say, well, that case doesn't really follow it anymore. You should go look at Putnell, which is another old Florida Supreme Court case. But Putnell can be reconciled with Indian River. If you look at Putnell, 49 Southern at 932, it talks about if the EUO was not waived, that's the EUO situation, it says then the action is prematurely brought, prematurely. And then you look at page 933 and it refers to remand and another trial. In other words, just because the insured violates some little policy provision, not a fraud provision, some policy provision, if there's no forfeiture provision, they don't get a walk. It may get postponed, which is what the Indian River case says. You have to go back. You have to give them the notice of loss. You have to give them or the proof of loss. You have to give them. Have to comply with the EUO, whatever it is. The insured has to comply, and that's delaying their payment. But you don't get a walk on that unless you have a forfeiture provision. So, unless there are any questions, we would urge that the court reverse, not so that the insureds can get the protection they paid for. An insurance company is not able to seize on any little thing to avoid a $100,000, completely valid $100,000 claim that they even acknowledge the loss is there for. Should be reversed on because the insureds cooperated and also because the two substantive grounds were wrong. Thank you.
Thank you, Mr. Elliott. You have about 6 minutes.
Thanks.
May it please the court, my name is Ezekiel Lugo, and I represent the appellee in this case, Tower Hill Prime Insurance Company, which I'll refer to as Tower Hill. This morning I have two main points I want to make on behalf of my clients, but before I do so, I would like to address two questions, one from Judge Sleet and one from Judge Kusan that perhaps are somewhat intertwined. Judge Sleet asked how is Tower Hill prejudiced in its investigation. Well, the prejudice to Tower Hill results from the substantive rights that are created under the neutral evaluation statute. In this case, neutral evaluation was requested before suit.
And there's something in the statute that says if that happens, you can't file suit?
Judge Northcutt, there's the stay provision that talks about any court
It
proceeding.
says stay.
It says
It
stay.
doesn't say, can't sue, like under the med-mal statute, like Mr. Elliott pointed out, does it? When
It
says
doesn't say
parties
can't-
will have access to the courts. What does that mean?
Judge Northcutt, it doesn't say they can't sue, but before I continue on that point, I would like to point out that that argument wasn't raised below, and the Met-Mal
Well-
statute was never referenced in the initial brief
Yeah,
or the
but
reply
it's
brief.
an analogy. It's the basic argument that the statute doesn't preclude suit has been made throughout, has it not?
Yes, Judge Northcutt. Now, the reason why that argument that it would preclude the initiation of suit, that comes from the Morjan case and the Buitrago case, where both Judge Lazara and Judge Crenshaw, writing from this court, say that the stay provision meant that the legislature intended that neutral evaluation would be a condition precedent to litigation.
Yeah, but you know what's interesting about both of those cases? In both of those cases, the carrier filed answers and defenses and then filed a motion to stay. Tower Hill did neither. They didn't even file an answer and defenses. They filed a protective order for no discovery at all, and they filed motions for summary judgment. So the cases that you cite didn't even follow the same procedure that you did. And
That-
Judge Lazara simply said, in Morahome, it's going to be stayed. He never said you couldn't file suit. And he never said that the statute precluded you from filing suit. And the statute's language itself says that any action shall be stayed, which contemplates something already being filed. Does it not?
Not necessarily, Judge Sleet, and going to what was said in both Morjan and Buitrago, in those cases, neutral evaluation was requested after suit had been filed. That's why neither case addressed the specific situation in this case.
Well, coming back to your argument that, there was prejudice, I interrupted you before you got that out.
Yes, so it was prejudice because the statute, Judge Lazara recognized, creates a statutory right for the parties to go to neutral evaluation and have the issue submitted to the neutral evaluation
Did that happen in this case?
decided.
That happened in this case, did it not?
That happened in this case, Judge Northcutt.
Notwithstanding that a lawsuit was filed, and notwithstanding that your side even filed motion to dismiss a motion for summary judgment while the neutral evaluation process was proceeding.
Right, but at that point, once the neutral evaluation took place and was concluded,
But how were you harmed?
and I'm getting to that point, Judge Northcutt, once that took place, Tower Hill was placed in a Hobson's choice. If it paid the neutral evaluation,
Neutral evaluation is not binding, right? So there was nothing that said that the Curtises had to accept.
right, Judge Northcutt, but the statute under subsection 15 says that if the insurance company accepts the neutral evaluation and complies with the evaluator's report, and then the policyholder rejects that recommendation, then that creates statutory rights for Tower Hill, in that it would not be subject to a bad faith suit or attorney's fees
Right.
related to the issue submitted
And
to the
how
neutral
is the
evaluation.
situation here any different than the situation that the statute, as you point out, the statute contemplates where neutral evaluation is commenced after a lawsuit is filed? How are you put in any different position than you were in this case? Have the same Hobson's choice.
But in the situation where neutral evaluation has been requested after suit has been filed, then the confession and judgment doctrine would be more opposite, in that there's been a suit, then the insurance company has invoked neutral evaluation as a way of resolving a portion of the claim. And if it pays at that point, then a confession and judgment may or may not have resulted. That would not fit the facts in this case, where neutral evaluation is requested before suit is contemplated to resolve this particular issue. If that's the case, and neutral evaluation proceeds, and it gets to the end, at that point, the insurance company should not be faced with the specter of a confession and judgment hanging over its head, because it requested neutral evaluation to resolve the issues before the suit was filed. So there would not be any judgment to confess. The statute would apply.
But, you know, you don't know that that's what would have happened, right? You could have made your argument against that, you know, on that position had this suit proceeded and there had been an issue of a confession of judgment. But that never came up, correct?
Correct. So the Hobson's choice would be that specter of confession of judgment, the deprivation of the right not to be subject to a statutory bad faith claim, the right not to be subject to fees under 627428 on the one hand, and on the other hand, if Tower Hill decided not to pay the neutral evaluation, then it would be subject to another claim of breach for not paying the neutral evaluation. Now, I want to point out that in the reply brief on footnote 12, opposing counsel points out that subsection 15 of the neutral evaluation statute immunizes Tower Hill from fees and bad faith exposure. If that were true, then there would be no need for opposing counsel to have filed a motion for appellate attorney's fees. That is just not correct. The immunization only results if Tower Hill accepts the neutral evaluation and the policyholder rejects it. If the policyholder accepts it, and this may answer your question, Northcutt, about the difference between requesting neutral evaluation before or after suit. If it's a situation where suit is filed, the insurance company requests neutral evaluation, it decides to go ahead and comply with that neutral evaluation and the policyholder accepts it, then there will be a confession of judgment in that case, and that option or that potential for the immunization from bad faith and or attorney's fees would not be present.
And how is that different?
That would not occur if neutral evaluation happens before suit and the decision is made before suit.
Lawsuit.
And there's no lawsuit, because there would be no judgment to confess.
Yeah,
Judge
but,
Northcutt.
never mind, go ahead.
Okay. Now, turning to 2 points I wanted to make this morning. The first one is related to, they're based on the two different motions that were granted by the trial court. The trial court correctly granted the third motion for summary judgment because neutral evaluation was a condition precedent under this policy. The policyholders did not comply with the state provision before suit, and the policyholders submitted no summary judgment evidence to rebut the presumption of prejudice that arises under the case law as to Tower Hill. And the second point is that the trial court correctly granted the second motion for summary judgment because the policyholders filed suit before their breach of contract action was perfected.
Okay, let me ask you about that one. That's based on the loss, the payment provision, correct?
Correct.
And it says that payment will be due within so many days after the parties reach an agreement,
Right.
after there's been a final judgment,
Right.
or after there's been a neutral evaluation.
Right.
When could payment ever be, or when could a party ever sue for payment under that provision? You know, other than the insurer denying coverage, when could there ever be a lawsuit? Because if there's an agreement, there's no need for a lawsuit, right?
Unless payment is not made within 20 days after they submit the proof of loss.
To enforce the agreement.
Correct.
But the final judgment, as Mr. Elliott points out, is pretty circular.
Well, not necessarily. That could address situations where there's a declaratory judgment brought before the court.
Talking about payment.
Right.
And neutral evaluation is not binding, so if the insurer accepts it and the accepts the amount and the insured accepts the amount, that's an agreement basically. So I mean, if you don't have that situation, I can't see into this provision how you're ever going to sue, you know, over a dispute over how much is owed. How's that?
Well, Judge, that may be the issue that's submitted to the neutral evaluator.
And neither party has to accept it.
Right, but if they do
at that
accept
point,
it,
where are they at that point? Can they sue?
if they accept it and 60 days go by and no payment is...
What if they don't?
If they don't accept it,
There's no agreement, there's no final judgment, There's no accepted neutral evaluation number.
Well, Judge Northcutt, in that situation, a declaratory judgment may be appropriate for the parties to bring before the judge.
So they have to get a declaratory judgment about whether they can sue over the amount that they should be paid.
No, respectfully, Judge Northcutt, that would not be the question before the court. It would be, in the context of this case, which is the appropriate method of subsurface repair? Is it grouting, like the insurance company's engineer determined, or is it grouting and underpinning as the peer review submitted by the policyholders claims?
Suing, saying, you know, they need to pony up for this versus what they want to do. I mean, that's what it's about, right?
Right, but under that situation, there would be no payment due under the policy yet. And if there's no payment due, and there's been no denial of a claim, then there cannot be a breach of the contract for failure to pay pursuant to the contract. The payment must be due, and that's what the Geico versus Grassi case out of the 4th DCA said. An insurance company's failure to meet a policyholder's demand for payment is not a breach unless payment is due under that policy.
Was it not?
Excuse me,
It was a venue case, was it not?
It was a venue case, Judge Northcutt, but it was looking at the venue provision determining
I know what it was. but
the accrual of the cause of
it
action.
was a venue case.
So the underlying, what I'm getting at is the underlying question was, did the cause of action in that case accrue? And that's the same basis of this motion. Did the cause of action for breach of contract accrue?
Dismissal, a judgment dismissing the case with prejudice?
Under Shuck, that would be the appropriate remedy, but again, that wasn't raised below. It was not requested in the initial brief, and it wasn't raised in the reply brief. So the argument was not preserved, and it was waived or abandoned on appeal. And under the Wright case out of the 4th DCA, the court there said, we're not going to grant the relief if it hasn't been requested before this court. Now, turning back to the argument on the neutral evaluation, the statute, as Mr. Elegant says, provides, quote, any court proceeding related to the subject matter of the neutral evaluation shall be stayed pending completion of the neutral evaluation. And I know the court has expressed concerns about the use of the word stay instead of saying that no litigation may be initiated. But under the case, there's a case out of the U.S. Supreme Court in Ken versus Holder that we cited in our
U.S. Supreme Court case?
answer brief. Yes, Your Honor.
Is this case involved with a federal question?
No, but the issue in that
So, I mean,
the issue in that case analyzed what does the word stay mean under the common law. And
yeah, but you know, here you have statute. We're not under the common law, and you have the legislature, which well knows how to write a statute that says you can't file suit, and that's not what they said here.
with respect to Your Honor, that is what it said, but the effect would be the same, taken into account what the U.S. Supreme Court has explained is a
But
stay
that's
means
not binding.
under the
That's
common
not
law.
binding on us.
It's not binding, but the legislature did define the word stay in the statute.
Well, why didn't they say? Why didn't they use that word in the Med-Mal statute?
I don't know, Your Honor, and again, I'm not prepared to address that argument because it wasn't raised below.
It's an analogy.
And it wasn't raised
It's
in
an
the brief.
analogy. I mean, you're asking us to interpret the statute and interpret the word stay as a bar to filing suit. And I'm pointing out to you that the legislature knows how to write a bar to filing suit in much more explicit terms, and they did not do that here. Now, I wasn't around below to make this argument, so I'm making it now. So, you know, how do we get there without interpreting the word stay in this way throughout the statutes?
Well, the way you get there, Judge Northcutt, is by looking at the purpose of the statute, which Judge Lazara and Judge Crenshaw, writing for this court, both said was to speed up the resolution of sinkhole claims and to minimize or avoid litigation.
Right.
Interpreting the phrase, any court proceeding related to the subject matter of the neutral evaluation shall be stayed, to bar not just the continuation of litigation, but also the initiation of litigation, would serve that legislative purpose.
But we're going to add to the statute in order to serve what we perceive to be the legislative purpose?
No, Judge Northcutt.
And frankly, to say that the purpose is to speed up claims, or the purpose of the neutral evaluation may be, but the purpose of the stay may not be. Because if the parties don't accept the neutral evaluation, the case goes forward, does it not? So all you've accomplished is a delay in the judicial resolution of the issue.
Well, Judge Northcutt, maybe the answer is in the policy, because the motion didn't rely simply on the statute, but on the statute as incorporated into the policy. And the policy in this case started with the insuring agreement that makes it clear that Tower Hill, the agreement between the parties here, is that Tower Hill is going to provide the insurance described in the policy, quote, in return for the premium and compliance with all applicable provisions of the policy. And that's on pages 15 and also on page 8. Of the policy. And one of the conditions in this case under the single coverage loss endorsement was neutral evaluation. So under the statute, one of the provisions that had to be complied with was neutral evaluation. In this case, after Tower Hill invoked the neutral evaluation, the policyholders, as they say in the answer brief, interpreted that as some kind of denial of benefits or refusal to make a payment, and they decided to sue Tower Hill. The policy also has the suit against us provision, which says that no action may be brought unless the policy provisions have been complied with. Neutral evaluation hadn't been complied with in this case.
Did the Curtises participate in the neutral evaluation?
Judge Northcutt, there was no summary judgment evidence submitted on that point. It's not in the record.
You did not, in your motion for summary judgment, prove that they did not comply with the neutral evaluation process.
Before the file suit.
Other than the filing of the lawsuit.
Right, Judge Northcutt.
So if we conclude that the filing of the lawsuit did not violate the neutral evaluation provisions, then this argument goes away, does it not?
If you find that the filing of the lawsuit did not breach the suit against us provision, then yes. But in this case, the summary judgment evidence showed that neutral evaluation was requested, and instead of going forward with a neutral evaluation before the suit was filed, the policyholders filed suit. That was in breach of the no action clause, the suit against us provision. And Florida law, it's clear that when there is a policy condition and a suit against us provision, the suit against us provision makes that condition a condition precedent.
So you're saying the suit against us provision contemplated that they could not file suit until the neutral evaluation process was ended.
Correct.
And you base that argument on the fact that the statute suggests that a suit shall be stayed.
In part, yes.
Neither the statute nor the contract explicitly prohibit them to sue before or during the neutral evaluation process.
Well, it wasn't just the statute, Judge Northcutt. It was the statute and the statements in Morajon and Weidner that both say that neutral evaluation is a condition precedent to litigation. If that is correct, and the policyholders do not go through with a neutral evaluation as a condition precedent to litigation, then there's been a material breach of the policy, which under Florida law relieves Tower Hill of its obligations under the policy. So it's not just the statute by itself in isolation, it's the statute, Weidner, Morajon, in the context of the policy provision requiring neutral evaluation and the suit against us provision making that condition a condition precedent.
I've helped you use up your time, Mr. Lugar.
Judge Northcutt, for those reasons, Tower Hill respectfully requests that the trial court, that this court affirm the trial court's rulings below and affirm the judgment.
Okay,
thank you.
Thank you very much.
For being such sticklers on what was and wasn't argued below, Tower Hill's awfully loose with its policy. Page 43 of the record is the sinkhole loss provision. It never, ever refers to subsection 10 on stay. The word stay is not in here. It is not in their policy. When you asked a direct question, you did not get a direct answer. The direct answer is no, there is no prohibition in their policy against filing suit. It says you may participate in neutral evaluation. May means may. The question, the beginning discussion about the safe harbor provisions, section 15 of the neutral evaluation statute, those provisions are, when you read them, they apply whether suit's been filed or not filed. Neutral evaluation is invoked once you're in suit. If they offer to pay the neutral evaluation award, they are not subject to bad faith, and they're not subject to the fee in that case. Now, that's not what they did here. They came in and tried to deprive the insureds of $100,000 plus in benefits by these maneuvers. So they're subject to a fee. We're here. We're here because of their leading the trial court into error. So they could have come in with a neutral evaluation and come into the case and said, Judge, we're going to do the neutral evaluation, we're immunized. They didn't do that. They seized on this as an opportunity to try to save $100,000, I guess, and deprive their insureds. The Grassi case, oh, I'm sorry, you already, that was the criticism for raising the Shook case. They raised the Shook case in their answer brief. I merely pointed out that they were wrong in the way they read it. They say the case should be dismissed. What the Shook case does is it says if you're going to dismiss a case as premature, you do it without prejudice. Namely, you don't enter a summary judgment. It stood for the exact opposite proposition they cited it for. I think I'm allowed to, in my reply brief, say how they were wrong in their answer brief. That's not a new point coming up. And finally, what I started with, and what you didn't hear for 20 minutes, is any distinction of my cry-loss. Didn't get mentioned. There was partial cooperation here. That precludes summary judgment. That's the starting point. Then they're wrong on the two merits points, too. But for all those reasons, we would encourage the court to reverse. Thank you.
Thank you both very much. We're going to do the